Welcome, and thank you all for standing by. I'd like to remind the participants that they'll be in a listen-only mode until today's question and answer session. At any time you do have a question, please press *1 on your touch-tone phone. Today's conference call is also being recorded. If anyone has objections, they can disconnect at this time. I will be turning the conference call over now to Janice Wingo, International Trade Administration. Thank you. You may begin.
Good morning, and welcome to this morning's webinar on how to protect your IP rights at trade fairs in China. This morning we have with us from Guangzhou, Chris Bailey, who is a partner at Rouse, and he is based in Guangzhou, and he's their deputy country manager there in China. Chris has been practicing IP law in China for about 12 years, and he speaks Mandarin. He advises many U.S. and multinational corporations on IP protection and enforcement strategies. He goes to the Guangzhou Trade Fair, which is coming up this weekend. He goes there many times. Yeah. They practically recognize his face when they see. They run when they see him. The bad guys do. And but also let you know that Chris is actually one of the creators of the Ciela IP litigation database, and you can access that database at www.ciela.cn. Chris has been so generous not only to speak with us today, but he said he'd be happy to take your questions. So anybody who is listening to the audio recording, you can email Chris, and he said he would be happy to take your questions. Anybody who's listening live, Kelly will tell you how you can, just ask a question during the presentation or at the Q&A part at the back. So, Kelly?
Again, if you do have questions at any time, that is *1 on your touch-tone phone.
Okay, Chris, take it away.
Thanks very much, Janice. One small detail is that I'm recovering from laryngitis, so my apologies for the growling. I don't normally growl, but I'll stick with it. Thanks very much for the invitation. Obviously, we're going to be talking about trade fairs in China, and I'll talk mainly about the Canton Fair, and that is the next session is coming up here in Guangzhou in a few days. Just running through what I'm going to cover today. Firstly, just some important key principles. A few stats about trade fairs in China. I'm going to talk about what companies try to achieve when they are policing IP at trade fairs. I'm going to briefly mention the legislation around enforcement of IP at trade fairs, and a little more detail about the Canton Fair, how it actually works there, and some issues that often arise there. Then briefly on other actions that you can take apart from using the enforcement mechanisms. And the last point here, exhibiting your own product. I haven't actually got a slide on that. I was going to leave that in case we run out of time. But we can talk about that at the end if you like. So the key principles that sort of we need to bear in mind before we kind of plunge into detail. I mean, the first obvious point is you've got to have registered IPR in China to be able to enforce. I mean, it's pretty obvious, but it's worth saying. And you need to prepare well in advance. And when I get onto the documents you need, you'll see why. But turning up at a fair, finding you're being infringed, and then starting to take some steps, it's too late. You've got to kind of know that you're going to have to enforce at the fair in advance. And the second point, when you see when I take you through how it actually works, you'll see that enforcement at trade fairs is actually pretty cosmetic, and it's only one. Dealing with problems at trade fairs is really only one part of a whole strategy that you're going to need to have to deal with infringement in China. If you're only patrolling trade fairs, then you're probably not doing enough. So those are two important things I wanted to sort of say at the very beginning. just a brief thing on trade fairs in China. I mean, there's I've got this chart here, which shows. I think this is really kind of international level trade fairs, and it shows China has, the fourth largest number of trade fairs after the U.S. Obviously, it's a highly export-driven economy, and that's pretty understandable. There's going to be a lot of venues where exporters are, going to exhibit their products. But we've seen other sources that there are maybe over 1,000 events which are described as trade fairs in China. So I think it's important for your industry to know what are the key fairs, not only that you might go to as a participant or that a U.S. firm might attend, but also what would a Brazilian buyer or an African buyer, where would they go to source products in your industry? There's a lot of smaller regional trade fairs which are worth keeping an eye on, because there's maybe where low-cost competitors, aka infringers, may also exhibit. I'm going to focus on the Canton Fair partly because the most enforcement goes on there, because it is, I'm pretty sure it is the world's largest fair. Just one session earlier this year, there was $37 billion of trade transacted. For those of you who haven't been, it's 1 million square meters of floor space, 22,000 exhibition booths. It's a massive event, twice a year. And the other thing that I wanted to say is, there are now many foreign organized trade fairs in China. In the past, particularly the Canton Fair, it was really a kind of emporium for pirated goods. I mean, you just walk around and you just spend all of your time compiling a very long list of people that were selling pirated products. It's of course a lot more sophisticated than that now, and a lot of the infringements are infringements of designs or patents where there's a more technical content. It may be a little harder to determine if somebody's goods are technically infringing yours. So the way that you patrol and the ability of, for example, of investigators to easily spot infringement has perhaps changed, and it might need more participation from you as the experts in your products. Now, I think this slide is really important. Is what are you trying to achieve when you're dealing with infringements at trade fairs? And probably the most valuable aspect of sort of patrolling a trade fair is the intelligence that you can get. It's an occasion when competitors and infringers will be gathering, and you can basically create a database of who they are. You can use it to really see what they're doing, prioritize which ones are the most egregious, and from an investigator's point of view, it's a great opportunity to ask questions and find out what infringers are doing when their guard is down, when they're open for business. They're probably more likely to reveal information about their markets and sales volumes than they would ordinarily. And you may have, if there are 10 infringers there, you can visit them in one day, as opposed to an investigator having to make 10 separate trips. So it's an obvious point, but I have a client, for example, who investigates, surveys the Canton Fair every session. They very rarely do any enforcement, but it's a very useful barometer for who's out there, what are they doing, has there been any change in the volume of infringements and the nature of infringements. So using trade fairs for intelligence gathering, I think, is very important. The second point is you can obviously use it for evidence gathering in a formal way. If you have a notary public, you can you can notarize the fact that an exhibitor is offering a particular product. You may be able to use that to establish venue at that trade fair. I can talk about that later. But there's obviously a use you can make of their attendance at the fair as formal evidence. And then finally, with enforcement, you'll see when I get onto the details that enforcement at the trade fair is important for taking products out of sight from buyers, but it's pretty cosmetic. There's no real penalties imposed. I've never heard of anyone being able to get a court injunction in the short space of time that a trade fair is held. So the kind of administrative enforcement is quite, it's quick, but it's quite simple. So you shouldn't have too high expectations of what you can achieve at enforcement at the fair. But it does also have the effect of formally putting the exhibitor on notice that you have a claim against them. And it may be useful as a form of warning in itself. So those are the things to sort of get straight in your mind when you think you're going to have an issue at a trade fair. What are you going to try and do about it? And I think, as I said, even if enforcement is not the best option, and many companies decide that, they will use the fair for very useful intelligence gathering. So I'm not going to go into the nitty-gritty of the legislation. I'm not sure that we have time for it, but I'm going to go through the procedures anyway, and I can always provide any of you with text of this legislation afterwards if you want to see it. Seems the formatting on my slides has gone a bit haywire here. So there's national level legislation, the one at the top, protection measures for intellectual property rights during exhibitions. That's been in force since 2006. And it's important to note that this only applies to trade fairs that are 3 days or longer and that are classed as international. So there's actually not that many major fairs that actually go for 3 days. When I say not many, I mean there's a lot of regional ones which are not so long. So you're only looking at very major events that this applies to. Then there are Beijing and Guangzhou, as far as I know, the only cities that have specific city-level regulations. They're very similar. And then the Canton Fair itself has its own measures. These are issued by the organizer. And the last thing I just wanted to mention is in the patent law, in the revised patent law, the Third Amendment, that offer for sale for design patents was created as a new type of infringement that wasn't there previously. So you can also rely on the patent law itself, where somebody is displaying an infringing product. Are there any questions at this stage?
I'm currently showing no questions on the phone lines.
Okay. I shall move on to the sort of nitty-gritty of the procedure. And again, I'm focusing on the Canton Fair because I know that is where by far the most IP disputes are handled, and that it's got the most well-established system. There are other fairs, obviously, where there are IPR complaint procedures under the 2006 regulations, they will broadly work the same way. So what I'm saying here should apply very much to any other venue as well. But as Janice kindly introduced, I am almost inevitable that I go to the trade fairs, the Canton Fair, and so I know this one pretty well. So preparation for the fair, there's a number of sort of practical things to do. One is that you can always get a list of the exhibitors in advance, and that tells you two things. Firstly, how many people in a particular category are exhibiting. If there's 60 or 70 exhibitors in your industry, and you have some hot products, and you know people are going to be very likely to be copying them, you could be facing 10 or 20 infringers in that section. So it kind of gives you an idea of how much work you're gonna have to do. And also you may see some familiar names that you've acted against or that you've seen elsewhere. So I think that's an important bit of preparation. You need to get your documents ready, and I've got the next slide covering that. I mentioned investigators before. I mean, it's quite common that even if you're attending yourself as an IP owner, if you've got issues on the ground in China that you're dealing with on an ongoing basis, you probably will have hired, you've probably engaged a law firm. They may have engaged investigators, or you may have engaged investigators directly. And it's important that if they're covering the fair, they know what they're looking for, but also to know if you're planning to enforce. You'll probably want them to give you booth numbers, exhibitors, pictures of exhibitors, samples, etc., as soon as possible on the first day, so you can get your complaint in. So the investigators kind of need to know what they're looking for, and are they supposed to be going in depth on investigations? Are they supposed to be quickly giving you a list of infringers so you can take action? If you're planning to sue any of the infringers, and again you may plan that if you see some old names that you want to take action, or if you are suing them and you want to obtain evidence, then it's a good idea to arrange a notary or have one who's going to be available at short notice. And an important small detail is that the Canton Fair has become increasingly strict about allowing PRC nationals into the exhibition centre, because it's basically supposed to be for overseas buyers. So it's actually quite hard to get locals in, and you need to make preparations for that. For example, an investigator can go in with somebody with a foreign passport, but there's limitations around that. So the documents required, I guess some of these are pretty obvious, and I should give a little warning here that we've found that the documentary requirements can be quite kind of capricious, and they might change without notice from session to session of the Canton Fair, and even between some officials they might ask for something which they hadn't asked for before. So there's often a little bit of negotiation required when we're submitting complaints, because we'll follow whatever's most recently been published, and suddenly somebody may ask for something new. But generally, this will hold true, because this is what is required according to the published list on the Canton Fair complaint guidelines. So for patents, you need the original or a certified copy of the patent certificate. You need a copy of what's called the extract from the patent register, which is actually a several-page document which shows the detailed drawings of the patent, and it shows that the patent is still in force. and that you obtain formally from the from SIPO. For trademarks, it's just the trademark certificate with all the pages that show again that it's in force, it's been renewed. For copyright, really the ideal thing is that you have a Chinese copyright recordal. If you've got a work of copyright that you're intending to enforce in China on a regular basis, it's much easier that you make a recordal. It's very similar in concept to the US copyright registration. So it's not mandatory, but it's very useful as a certificate which gives you prima facie evidence that you own copyright. So ideally you have that recordal certificate, or you can have a US copyright registration, but that will need to be notarized and legalized. And then again, for the Chinese recordal certificate, you need the copyright search report, because that will actually show you what the work is. The copyright recordal doesn't actually show a sample of the work. And then for all of the above, you're also going to need, I guess I should work from the bottom up, a power of attorney, to whichever agency or law firm is going to be representing you, or the individual. If one of your own company representatives is going to be doing this, you need a declaration that the power of attorney is signed by somebody who is duly authorized to sign on behalf of the company. And then you need the company registration or certificate of good standing, and all of those need to be notarized and legalized and translated. So you can see that this is not something you can organize at the time or a few days earlier. You've got to have a lead time of at least a month, if not longer, to get all of these together. So if you're going to, say, the Canton Fair for the first time and you find some infringements, you're probably not going to be able to take action unless you have amazing powers of persuasion and you're able to rustle up documents that cover most of these areas. It's more likely that you're going to have to wait till the next session and have all of this prepared for the next one. The complaint process itself. This is probably the most important thing. This first point here. The complaint office. So there's staff members from the AIC. This is the body that has jurisdiction for trademarks. There's staff members from the State Intellectual Property Office, and then the Copyright Bureau. They are the complaint center is a kind of a extra jurisdictional entity. They're not there with their normal powers. They're being asked to to determine infringement within a few hours, when normally they'd have much more time, and then so they're not really there enforcing their enforcement powers. They're really there advising the organizers, and the action is really taken on the basis of the kind of terms of business that the exhibitors have signed with the trade fair organizers. So you're not really talking about a normal administrative enforcement that you would get if you went to, outside of the fair, if you went to the AIC or you went to the Intellectual Property Office. In other situations, you'd get a much more complete process, and there would be a penalty and an infringement decision. So it's important to bear that in mind. So you submit your complaint form, and obviously any information you've got on the infringer, the booth number, the sample pictures, if you can get them. The relevant IP officer there will verify your documents. For example, they may look online and check the validity of your patent or your trademark. then the IP officer and maybe one or two of the fair officials will go to the infringer's booth and they'll ask them to take the infringing articles down and sign an undertaking. That has to happen right away, but the infringer is given 1 day to sort of argue back and present evidence that they're not infringing. But in the meantime, the goods have been taken off display. And then at the end of the fair, notifications will be issued. And I've got a sample of that in a later slide, but you'll see that these notifications are, it's not a penalty decision, it's not a confirmation that there's been infringement, it's simply a notification of a complaint. And it's issued actually in the name of the fair organizer, so not by the enforcement authorities themselves. So there's some issues, practical issues that actually unfortunately make the enforcement process perhaps rather weaker than it should be. Firstly, there's quite a large volume of cases, certainly at the Canton Fair, and we'll always find that the complaint office is sort of extremely busy. There's lots of people queuing up and shouting and waving pieces of paper, and if you haven't got your complaints in sort of really by the afternoon of the first day, you're going to be sort of behind a stack of others, and by the time the officials get around to your complaint, it may not, they may not be actually taking the products down until the third day of the fair. So that's why it's a good idea to do your preparation, get people sort of running around and spotting infringements as early as possible, getting all your paperwork ready and compiling your complaint and getting it in sort of really the afternoon of the first day. Then you've got a really good chance of getting the offending products taken down as quickly as possible. The point I've already made is it's only a notification. There's no actual penalty because there's no actual determination of infringement confirmed at the fair. Sometimes, annoyingly, the exhibitor will actually put the infringing product back on display. It doesn't happen that often, but we have seen it. And what's supposed to happen is that the exhibitor has their fair passes removed, but I've never seen that happen. And just sort of skipping down to the fourth point there are rules that bar exhibitors if they have repeatedly exhibited infringing products, but the details of those rules are pretty impractical. It has to be 2 sessions in a row and in the same name and the same subject matter, and it's very easy for an infringer to appear in a different name or use somebody else's booth. So in practice, it's very, very unlikely that you're ever going to get somebody barred from attending the next fair. And the point that I just made, which is that the person who is officially registered at a particular booth number may not actually be the manufacturer or the infringer that you're trying to deal with, because there are some trade associations and trading companies that will rent a whole block of booths, and then they'll either sort of sublet them or their best friends' suppliers will use those booths. So the notifications will be issued against the owner of the booth, but that's not necessarily the company that you are dealing with. That's not necessarily the infringer. So that can be that can cause difficulties. 2 other very important barriers to enforcement. One is that if you're enforcing or trying to enforce a patent, a design patent, for example, or any kind of patent, which is against which an invalidity action has been filed, won't be able to enforce that at the fair. Now, the IP office may know that by checking the SIPO database. If the invalidity action is recently filed, of course, the database may not be up to date, so they may not discover it. But the point is, it doesn't have to be an invalidity filed by the person you're complaining against. It could be just anyone. It then basically means that your rights are potentially in doubt. And so, for the purposes of the trade fair, the IP office don't want to won't take action. And the second rule, which is, and this is for the Canton Fair, the complainant is not allowed to make another complaint at the next session for the same IPR against the same infringer without proof that they've taken some other form of action. In other words, the organizer doesn't want you to keep complaining at the trade fair only. If you've got if you're claiming infringement, you need to have taken administrative or judicial action subsequently. You can't just keep showing up at the fair and making the same complaint against the same person. That's the idea behind it. Now, in practice, let's say you're talking about the Canton Fair. There's only really 6 months between the sessions. You're unlikely to have got a concluded case. But if you can show that you've got, say, even a customs report, or you've filed an administrative complaint or a suit in the civil court, it doesn't have to be concluded. You just have to show that you are taking some form of action. So those last two are quite important. The last one, particularly for the Canton Fair. These are sort of barriers to action, which certainly bodies like the European Chamber of Commerce and I believe the American Chamber of Commerce have noted and made some complaints about, because these are considered to be rather unreasonable obstacles to enforcement at trade fairs.
The Secretary of Commerce has actually noted it.
Okay. The last point here is just to give you an idea, again from the Canton Fair, that the 109th Fair is the session this year in May. So there were 826 complainant companies. 616 of those complaints were accepted. So I mentioned earlier that sometimes the documents are not always there, or there's other issues that the officers feel they can't act on. So you can see there's quite a lot of complaints are not accepted. And then of those, a much smaller number are then acted on. And then you've got a breakdown here of the type of IP involved from the complaints. So 70%, the vast majority, are design patents. Smaller number of trademark and copyright. And that really follows what I said earlier about blatant trademark infringement being much less common now at trade fairs. Trying to go to the next one. Is it going through? Here we are. Yeah. So this is just an example of the notification that you get following a complaint. So you can see it's a notice of suspected infringement. Actually, that's not the best translation looking at the Chinese, but that's what that's our translation of what it is. And then you can see that it says that the claimant's filed a complaint against the booth number. Hello, can you hear me, by the way? So I've got a message saying I've lost the connection.
I can hear you.
Okay.
Operator Kelly, can you reach out to that person and see if we can help them on their audio?
Okay. What's the person's name?
If you can send me an email, it's janice.wingo. I can get Kelly to contact you online, so maybe we can get some audio to you.
Okay, I've got a message here saying lost connection, but if you can hear me, then we're fine.
Yep, I show your line is connected. I show several parties still connected in conference.
Okay.
So.
Okay, great.
Yep.
All right. So going back to this document here, it's basically saying that the person who is owning who is exhibiting in a certain booth number has been accused of infringement. They've been suspected of infringement, and according to the rules of the Export Commodities Fair, the products have been disposed of. That means generally it means they've just been asked to take them down. So none of this is in the name of a particular enforcement authority. None of this is saying that there's a confirmed infringement. And you can see it's signed by the complaint reception office of the fair rather than in the name of a particular enforcement authority. So this is not. It doesn't mean that it's worthless. As I said, it's useful as a in any follow-up action. It's useful to show that you've put the other party on notice of an infringement. If you notarize, you may be able to establish venue, for example, in Guangzhou, if somebody has committed infringement by offering a design patent infringing product for sale. But on its own merits, this document is not a penalty decision or a full force administrative decision. And then the last thing I really want to cover is kind of echoing one of my earlier slides. What other things can you do? Well, obviously, in the course of your investigations, you may find out if the exhibitor has overseas offices. You may find out who they're selling to, whether they're attending other fairs. You can kind of build up a profile of what they're doing. And most importantly, you're very likely to use the information you've gathered at the fair to find out who you should take action against outside of the fair. So for the investigators, if they've managed to meet key salespeople or a senior person at the time when the infringer is sort of, as I said, open for business, they're going to find it much easier to follow up. They've gained credibility from attending the fair, and then you can do an effective investigation and hopefully some enforcement. As I said, you can notarize infringing products, and certainly for Guangzhou, the courts seem to be willing to establish jurisdiction in Guangzhou for a company which is domiciled outside of Guangzhou but has come to the fair and is exhibiting, is infringing by offering for sale patent infringing products, as I mentioned. So that may be an advantage that you'd sue them in Guangzhou on the strength of their attendance at the fair. Some people have tried issuing warning letters, handing out warning letters instead of going through the enforcement process, or as well as the enforcement process. Nothing wrong with that, except normally people want the letters to be signed to acknowledge receipt, and maybe even somebody to sign undertaking. It's very unlikely that the sort of salespeople have the authority or would do that at the trade fair. So it's more of a gesture than something that you're going to it's a way of putting them on notice, but you might not necessarily get the results you expected. And I think the last point is, don't sit there and wait for the next trade fair to come around and do the same thing again. If you're not using the trade fair as a way to assess who's out there, gather intelligence on them, and then follow up with some enforcement, then you're probably not doing enough. So this is really where policing your IP and enforcing IP at trade fairs fits into a much broader strategy. So that's really it for what I wanted to cover this morning. I said I didn't cover the last section on if you're exhibiting your products, but if that's of interest to anyone here, I can talk about that now, and welcome any questions now or by email or on the chat facility.
Thanks, Chris. If anybody's listening on the audio recording, you can email Chris at cbailey@iprights.com. He said he'd be happy to take questions.
And again, remind the participants if they have questions on the phone lines, that is *1 on your touch-tone phone for any questions or comments.
I also want to remind the listeners that next Tuesday, October 18th at 1 p.m. Eastern, there will be a webinar by a practitioner in Beijing on licensing your trademarks. So that's at 1 p.m. on October 18th. You can contact me for the login as well. It's Janice Wingo, JANICE.WINGO@trade.gov.
Excuse me, I do have a question from Ed Harwood. Your line is open.
Thank you. Thank you very much for your presentation and insight. I wondered, though, as a practical matter, how enforceable IP rights are in China. I have heard a continuing, I guess, negative story for at least a year and a half now, that it's not in the best interest of China to enforce any of this.
That's quite a big question, but I'll try and answer that simply. Dealing with your question sort of in reverse, at the central government level, I think it's clear and unequivocal that they recognize that it's in China's interest, not only long term but now, to have a robust IP regime and to encourage Chinese companies to be IP owners. And in fact, if you're looking at the sort of bare statistics on the number of trademark and patent applications being made by Chinese companies, that's definitely happening. In the past few years, it's been increasing. And also, if you look at litigation, of the 30,000 plus IP litigations in the last few years, certainly it was above 30,000 in 2008. 96% of those are between Chinese companies. So there's a lot of IP owned, and there's enough value in that IP that Chinese companies are suing each other over it. So I think that's the sort of macro view. I think the negative stories are, it really depends what type of IP you own and which industry you're in. If you're in the movie industry or the software industry, piracy is still a big issue, and enforcement is still perceived to be very inadequate, particularly criminal enforcement. And there's just a huge volume of piracy, at all levels of society and business. If you're a trademark owner, you've got some pretty good enforcement channels. You've got the administrative system, which is a sort of blunt instrument, but pretty fast. through, say, the AIC. The court system is getting very mature, and a lot of foreign companies are using the courts regularly now. And then you do have the criminal system. And I would say the drawbacks are they don't always fit together very well. Each of these systems has some flaws. And if you catch it kind of all the wrong way, you can find it's lacking. So I'm not going to say that it works perfectly, but I think it's important for companies to do their research, not follow the sort of media headline stories, to speak to practitioners, both foreign and Chinese, and get a more rounded assessment. That's the only advice I can give.
Thank you.
And I just wanted to add that while the Department of Commerce cannot offer legal advice, we do have materials on our website, which is stopfakes.gov, www.stopfakes.gov, that can help you in conjunction with your lawyer. They can help you enforce your rights. We're also very happy to speak with you. The number is 202-482-2590.
And I can continue to show no further questions on the phone lines.
Well, Chris actually has a very sore throat today, and we appreciate him speaking to us today. If you'd like to email Chris, maybe he'd be able to write back at cbailey@itrights.com. He's in Guangzhou.
Yeah.
He'll be at the trade fair. He said he'd be happy to take questions. And then we will post an audio recording of his presentation to the stopfakes.gov website. And I just want to remind you about the October 18th webinar on trademark licensing as well. So if there are no other questions, again, I'd like to thank Chris Bailey of Rouse for his presentation today. And I'm sure, Chris, that quite a few people will be emailing you in the not-so-distant future.
Sure. Well, thanks very much again for the invitation. And it's a pleasure talking to you all today.
Goodbye.
Okay. Thanks very much. Goodbye.
Thank you, and that concludes today's conference call. You may all disconnect at this time.